When you have minor children, planning for your family's future can feel like navigating a complex maze. The thought of what would happen to your hard-earned assets can be a heavy burden, especially for something like your home. No one wants to create bad karma. Many parents want to ensure their children are provided for without unnecessary complications or delays. If you're a Virginia resident and you're wondering how to protect your home and other assets from the often lengthy and expensive process of probate in order to protect your minor children, you're in the right place. Today, we're going to demystify how a Virginia revocable living trust can be a powerful tool in your estate plan, offering peace of mind and secure provisions for your loved ones. Let's first understand the challenge. Without proper planning, when you pass away, your assets, including your home, would typically go through probate court. Probate is a legal process that validates your will, pays your debts, and distributes your assets according to your wishes, or state law if you don't have a will. While it serves a necessary function, it can be time-consuming, costly, and importantly, public. For minor children, this means that any inheritance they receive might require a court-appointed conservator to manage the funds until they reach the age of majority, typically 18. This conservatorship process adds another layer of court oversight, potential fees, and a lack of direct control over who manages your children's inheritance and how it's used. Imagine a situation where your children inherit a substantial sum at 18, an age where financial maturity is still developing, or where the funds are tied up in court for years. This is precisely where a Virginia living trust steps in as an elegant solution. A living trust is a legal agreement that you create during your lifetime. When you make a living trust, you transfer ownership of your assets from your name into the name of the trust. The idea is to put all of your assets, such as your home, real estate, bank accounts, and investments, in the trust. Because it's a living trust, you would also serve as the initial trustee, and you would maintain complete control over your assets just as you did before. The beauty of a revocable living trust is right there in its name. Revocable means you can change, amend, or even completely revoke the trust at any point during your lifetime as your circumstances or wishes evolve. So, how does this protect your home and other assets from probate for your minor children? When your assets are owned by the trust, they bypass the probate process entirely upon your passing. Instead of going through court, the successor trustee, whom you've carefully chosen in your trust document, steps in to manage and distribute the assets according to the specific instructions you've laid out. This means a seamless, private, and generally quicker transfer of wealth to your children. More importantly, for minor children, a living trust allows you to dictate exactly when and how they receive their inheritance. Instead of an outright distribution at age 18, which many parents find too young to gift a child a significant sum, you can establish staggered distributions. For example, you might specify that they receive a portion at 25 and the remainder at 30, or at any ages you deem appropriate. You can also guide how the funds are used, for example, for their health, education, living expenses, or other support, so their needs are covered but managed by a responsible person. While an IRA is typically governed by beneficiary designations, you can name your living trust as the beneficiary of your IRA, so long as the trust is carefully structured to manage it. But directing the IRA proceeds to pass through the trust can be a critical step because it ensures that those funds are protected instead of being distributed directly to your minor children, to an irresponsible adult child, or claimed by a beneficiary's creditors. Once in the trust, your chosen trustee will manage them according to the provisions you've established, safeguarding them from creditors and probate. This strategy ensures that all your key assets are 1. Unified under one comprehensive plan, 2. Managed by someone you trust, 3. Protected from creditors, and 4. Distributed precisely according to your wishes, all while avoiding the complexities of probate. In summary, a Virginia living trust offers a flexible, protected, and private way to protect your assets from probate for your minor children. It ensures that your wishes are honored, provides controlled distribution of assets at appropriate ages, and avoids the often cumbersome and costly process of court-supervised estates. If you're ready to secure your family's financial future and ensure your children are cared for exactly as you intend, I encourage you to take the next step. Don't leave your family's legacy to chance. Contact our office today to schedule a discovery call to learn how we can help you. Our attorneys can prepare a plan that fits your specific needs and provides you with the peace of mind you deserve. We look forward to helping you protect what matters most.